Hey everyone, it's Sameer Khedekar, the tech visa lawyer. Why are EB-1 adjudications seemingly so subjective? Well, there's a really good reason for that. It's because of this federal district court case that came out maybe about 10 to 12 years ago called Kazarian. And in that case, the judge, it was actually a really good case for us, for immigrants, and for EB-1 because it admonished USCIS for saying you can't require things that are not within the plain language of what the regulations say. So we often use that case to support our arguments. Hey, USCIS, stop requiring things that are not required. But kind of buried within that case is a concept that the court referred to as a final merit determination that said, well, they may want to kind of look at everything in totality and then see whether or not the evidence kind of supports the contention that this person is at the very top of their field. USCIS jumped on that, called DICTA, this language that really had nothing to do with the actual ruling, and made it their policy. Created the two-step analysis. The first step meaning you have to meet at least 3 of the EB-1 criteria. The second step is that the government can take a look at all the evidence together and then assess subjectively, is this person appear to be at the top of their field? So that is what's been happening. And it really struck a lot of fear in the hearts of lawyers because we were like, oh my God, and now they can just do whatever they want, right? If it's like the subjective whim of the officer, then what does it matter what background somebody had? What really happened for the most part over the years is that it never really came up. I think maybe something like 10 to 15% of denials actually were denials based on the final merits. They really focused their efforts on denying based on the first step, which is we don't think about the criteria. But I think we're starting to see more and more their use of invoking final merits as a reason to deny cases. And we just had somebody who met 4 of the criteria but was denied on final merits, and we could have easily taken this one to court, and I think we would have won. Thankfully, we chose not to in this case because this person just got some more awards and some more evidence, and so we're just going to refile and I think it'll get approved. But keep an eye on this. This is where USCIS can really just apply the subjectivity of the individual officer who's looking at the application and just create a really bad precedence for unpredictability and no transparency and no regularity and kind of what it means to be the government standard for extraordinary. So we'll keep an eye on it, keep you updated. In the meantime, if you have any questions, feel free to let me know. info@banyan.law. Thank you.